Good morning, everyone. A very warm welcome to this edition of In-House in Focus, our seminar series, and today's seminar on navigating greenwashing, key responsibilities for in-house counsel. My name is Alison Ross Eckford. I'm a partner in our London commercial team and lead partner of our multidisciplinary ESG legal services. Before I introduce our speakers, I just have some quick housekeeping notes for you. This webinar is being recorded, so a copy will be circulated after the session, and it will be available on our Mills & Reeve website under In-House in Focus. And also that's along with our previous recordings in case you've missed any of those sessions. For any questions you might have for our speakers during the presentation, please would you use the Q&A function rather than chat. The chat function has been disabled, but there will be time for Q&A at the end. And finally, there'll also be an opportunity at the end of the session for you to leave feedback. Please do. There's an open text box where you can leave comments. And in particular, we'd be interested in hearing about topics which might be of interest to you for next year, since we are planning those topics now. So if you have any suggestions around that, those would be very welcome. And the next In-House in Focus session is on Wednesday, the 16th of October, and invitations will come out shortly for that as well. Right, well, I'm delighted to be joined today by two of my colleagues who will be leading this session on navigating greenwashing. Katrina Anderson is a principal associate in our commercial team and an expert in digital and consumer regulation and advertising and marketing law. And Judith Houston is a senior associate in our corporate team with an ESG focus. And she advises particularly in relation to directors' duties and corporate governance. So I'll hand over to Katrina, please.
Thanks very much, Alison. Right, so I'm going to talk to you a little bit about greenwashing, first of all, and then I'm going to hand over to Jude, who's going to talk to you about directors' duties and finish up with some tips on how to stay ahead of what is a very, very fast-moving world at the moment. And by way of illustration, oops, apologies, those were Alison's slides, but we'll start here. By way of illustration of this, I just wanted to give you a little bit of history about the enforcement that we've been seeing in the UK. So this sort of history of greenwashing enforcement, if you like, as we know it in its current form, started back in September 2021, when the CMA published its Green Claims Code. And this was a bit of guidance basically setting out how the CMA thought environmental claims should be treated. And it was to apply to environmental claims wherever they were made, advertising, packaging, on your website, sustainability report, the lot. And they very unusually said, right, we're giving you, the world, if you like, businesses, but not just businesses, until Christmas to get your house in order. And this was a sort of grace period from enforcement from the CMA. And we actually didn't hear anything until about 6 months later, when the CMA announced that it was going to do its first investigation into greenwashing, and they were going to focus on fast fashion. That investigation rumbled on for about 2 years and finally concluded in March of this year, with certain companies giving undertakings about what they would do going forward to clean up their act in terms of green claims. And we'll touch on what those undertakings, what we can learn from those a bit later on. But before that had even concluded, actually 6 months beforehand, the CMA announced its next investigation, this time into consumer goods. And that one is ongoing at the moment. And everyone expects that at some point there will be a third investigation that is launched by the CMA. There have been various ideas as to what sector this will focus on. I've heard travel a lot. I've heard food and beverage quite a lot. Nobody knows for sure, but I think it is clear that the enforcement is going to continue by the CMA, and those investigations take a long time. So let's flip to the ASA now. Now, the ASA has a much longer history of enforcement in relation to green claims. And if you look back before 2021, you can see that kind of year on year, we sort of saw 5, 6, 7 decisions by the ASA on this topic, and sometimes people won them, sometimes they lost them. It was kind of one of the topics the ASA covered. What has happened since the CMA started enforcement is the ASA has entered into a specific memorandum of understanding with the CMA about how they're going to work together on greenwashing enforcement. We know they have weekly meetings to discuss, and it has resulted in a huge uptick in enforcement, partly because the ASA has switched on the bots, and the bots are the AI bots that kind of creep around the internet and try and find problematic claims. And they've switched them on for certain sectors like food and beverage to try and find claims, but they're also encouraging complaints in. So we've seen about a threefold increase in decisions on this topic. And rather than previously, it used to be sometimes you win, sometimes you lose. Recently, the examples of complaints not being upheld have been very, very rare. We had one in 2022 and one in 2024, but all the rest have been at least partially and mainly fully upheld. So there's a lot more enforcement from the ASA, and it's becoming a lot harder to win those decisions. So let's just cycle back. We're obviously living in this world where we've got a lot of scrutiny, a lot of enforcement going on. But what are we actually enforcing here? Well, the thing about green claims is there is no, at least at the moment, specific bit of law on green claims. Rather, what is being enforced are the general rules about advertising. So we're basically looking at these based on the general advertising principles, and that's what they're rooted on in law. And it is about being misleading, and it's about things that would be misleading to cause the average consumer to make a transactional decision they would not otherwise have made. And this is currently set out in the Consumer Protection from Unfair Trading regulations. It will be, in due course, from we think April next year, replaced by the Digital Markets Competition and Consumer Act, which is restating those regulations. But that won't change this position. That is the law that we are talking about. But in this area, it is really all about how that law is interpreted. And if you go back, we have had for a very, very long time, as far as I know, since the beginning of the CAP code, there has been a section specifically on green and environmental claims. And they have set out many of the principles that we talk about today. So it talks about claims needing to disclose any significant information. It talks about needing a high level of substantiation. The rules talk about needing to have a life cycle analysis of a product to substantiate a claim, that you mustn't present things that you have to do as a matter of law as a benefit. These are all in the CAP code and have been for a very long time. But prior to 2021, I think it's fair to say we didn't really treat environmental claims any differently to any other claims that were caught by the CAP code. And in actual fact, I remember prior to 2021, I presented on this, and a client came back with a question afterwards and said, what does a high level of substantiation mean? So we actually went and we consulted and asked the regulator and said, well, what do you mean by this? And they came back and said, oh, no, we just mean the normal level of substantiation. I can tell you now, if I went and asked that question today, that would not be the answer that I would get, because all of a sudden, all of these principles that have kind of existed for a long time are being very, very proactively enforced. And they have been effectively reiterated in the CMA's Green Claims Code. So the CMA's Green Code, in the main, if I'm honest, has not changed the position that we had under the CAP code, but it has reiterated it, and it has done that at a point at which suddenly we've got this uptick in enforcement, and suddenly we're taking all those extra things that always applied to environmental claims as being really, really significant and important because of the enforcement risk. And that said, there are a few things that are worth knowing about the Green Claims Code, which are sort of nuances, if you like. About a little bit about how the ASA and the CMA do still look at things slightly differently, but also about the direction of travel that this has taken us in. So the first thing to bear in mind is that the Green Claims Code applies everywhere. So the ASA CAP code only applies to what is legally considered advertising. That's wider than you would think, in the sense that it'll cover your website, it'll cover social media, it'll cover lots of things that are not immediately obviously advertising, but it doesn't cover some important things like packaging claims, or it might not always cover things like sustainability reports or shareholder reports. That's all a bit kind of debatable. The CMA Green Claims Code definitely covers everything wherever you make a claim. So that's an important point to take away, first of all. The second thing is that we are really living those principles that were in the CAP code. So we are treating the default position that if you make what we now call an absolute environment claim, so if we say something is green or sustainable or better for the environment, we just make one of those really bold absolute claims. The default position is life cycle analysis. And that means that you need to have data that shows from the beginning of whatever product and service you are offering, from its ingredients or how it's made or every aspect of that product, all the way through, how that product goes to consumers, how it gets to market, how it is consumed or used, or the services used by consumers, all the way through to disposal of any packaging. You need to look at that in its entirety. And if you want to say that your product is green, then the bar is no environmental impact, which is an incredibly high bar to make. So it is becoming very, very difficult to make those absolute claims. We also now know that if you want to talk about how you're on what's called a mission, so an environmental mission, so maybe you have goals that you are going to, I don't know, cut your use of plastic in half, or you're going to reduce your carbon emissions by a third. What is now expected is that you will have a written plan with KPIs. You will have a deadline for that, which is a reasonable time, and you will monitor compliance with those. We also know that if you are relying on third parties for your substantiation, the CMA expects you to be contractually obliging them to provide that, collecting that, reviewing that, keeping that up to date. So there's a whole sort of impact, if you like, of living this and living those principles that have been in the law for quite a long time. The other thing that I think is worth mentioning is there is a little bit of a nuance about, I think, the difference between the ASA and the CMA. Although they are working very much hand in glove in terms of the enforcement, the ASA is still looking at green claims as another form of advertising. So, the things that we know about the ASA, for example, that they don't generally like disclaimers, still apply in the context of ASA enforcement. The CMA has a slightly different focus, and they are very much, if you read the Green Claims Code, there is a focus on transparency of information. So they are pushing more towards disclosures in ads, and that information needs to be provided at the same time as the claim. They also seem to have a slightly different approach to substantiation. So the ASA would not generally say that you need to disclose substantiation unless it is a comparative claim, whereas the CMA seems to be, through the Green Claims Code, encouraging disclosure of substantiation information as a way to ensure that claims are not misleading. So depending if you are in the unfortunate position of dealing with enforcement, who you're talking to, there may be a little bit of a nuance on how it's interpreted. But it is, I think, as we are today, the Green Claims Code is probably our most important expression of the law as it stands in terms of environmental claims. And it should be how you are reviewing any claims that you want to make going forward. And I've picked out a couple of examples of what the Green Claims Code means in principle. And these come from the code itself, but they're quite sort of interesting illustrative examples. So the first one is of what we call an absolute claim. So the absolute claim here is organic. And what the CMA is saying is that you need to think about the overall impression that if you say organic in this context for genes means to consumers. And they say, a bit like the life cycle analysis, the default here is consumers will think that it is fully organic. If, as a matter of fact, the cotton in your jeans is maybe a mix of organic and not organic cotton, in this case 35%, then that's material information that needs to be disclosed to the consumer. And so therefore you should be making a claim which is more like 35% organic genes. The next one is about making claims about one part of your product. And this comes to this life cycle analysis. So as I said earlier, if you are making a claim that your product is environmentally sustainable, that is an absolute claim. So it will apply, unless you say otherwise, to your entire life cycle of your product. So if you say this soup is nature's friend, better for the environment, then that would be misleading if, as a matter of fact, actually this product has some important non-environmentally friendly aspects to it. In this case, that actually it's in non-recyclable plastic carton. And so you would need to narrow your claim to make it clear that you're actually only talking about the ingredients being sustainable and the soup itself, not the packaging. And you might also need to disclose that the packaging is, as a matter of fact, not recyclable, because you have to combat the overall impression given by your claim as well. The next couple of claims are about comparisons. And one big thing I would point out to you as an advertising lawyer, and I still don't, it's a mystery to me why this is the case, but the Green Claims Code does not mention the comparative advertising rules. The comparative advertising rules apply when you make a comparison to your competitor. So if you say my product is more sustainable than my competitor's product, even if you don't name that competitor, but you imply it, then that is a comparative claim and the comparative advertising rules apply. They do not apply when you compare your current product to a previous iteration of your product. That is not something that triggers the comparative advertising rules. The Green Claim Code talks about both of those forms of comparison, but for whatever reason doesn't remind you that the comparative advertising rules still apply. I would remind you, as a matter of law, they do still apply. So in addition to thinking about the rules in the Green Claims Code, you should also think about those comparative advertising rules as well. And it is worth flagging to the business that the comparative advertising rules are very fiddly to apply, such that it's very difficult to know that you are absolutely 100% compliant. And there is, by definition, somebody who is likely to make a complaint. So it is always lower risk to compare to yourself than compare to a competitor. If you decide, as part of your comparison, to use your competitor's IP, then you will increase the risk significantly, because that means that you've potentially got a claim for IP infringement as well. So those should be factored in as well. Okay. So that's some examples from the Green Claim Code. I just want to very briefly touch on some learnings that we're getting from rulings that are coming out at the moment and what those mean. And then I'm going to finish up on what we can learn from the undertakings and hand over to Jude. So first of all, recent rulings we've seen, Wessex Water. So the context to Wessex Water was that Wessex Water was given a 2-star rating by the Environment Agency due to the fact that sewage was overspilling into water. They were required to do something about this, and they did lots of plans to deal with this issue. And then they produced a very nice glossy TV ad explaining what they were doing for consumers. And this ad went to Clearcast for approval and was approved on the basis that those claims could be substantiated. Notwithstanding this, there was a complaint and the ASA investigated, and it said that actually, the problem with this ad was the overall misleading impression was that it suggested that these wonderful things that Wessex Water was doing, they were doing kind of voluntarily. They were additional environmental benefits, when actually they were doing it because they had been found out as having a very poor environmental record. And the fact that they had that poor environmental record was significant material information that should have been disclosed in the ad. So this is really all about whether you can claim something that you are doing for reasons which are effectively to do with legal compliance as a sustainability benefit. And it's a good illustration of the challenges around that. You might be able to make some claims about it, but if you do, you're probably going to have to disclose why you're doing it, which might somewhat undermine the marketing benefit of it. And the next one is about Virgin Atlantic. And this is all about sustainable aviation fuel, which is a term used in the industry to refer to fuel, which is, to be fair, a lot better for the environment than regular aviation fuel, but it is not net zero. It does not have no carbon impact or impact on the environment. And the ASA found that using that industry term in communications in a radio ad to consumers was misleading because a third of UK consumers understood that to mean that there would be no environmental impact to that flight. And I mention this one because it's a rare example of the ASA using numbers and sharing the numbers that they have seen in terms of substantiation. Because a different way of looking at this is 70% of UK consumers actually understood that sustainable aviation fuel was not no environmental impact. But even though most UK consumers understood that point, the ASA said a third being misled was still sufficient to mean that this was overall misleading. So they're being very harsh on the substantiation data. And then finally, I'm going to touch on recycling claims because we know these are a focus at the moment for enforcement. And the key things to think about with the recycling claims is if you say something is recyclable, the working assumption is that means in most of the country, a consumer can chuck this into their recycling bin at home, curbside recycling, and that product will be taken away and all of it will be recycled. That's what that claim is being understood to mean. If actually only parts of it can go in that bin, or actually you need to take it to maybe a supermarket because mostly that's not something you do through curbside recycling, or it needs, worse still, some kind of specialist recycling, then that information is material and will go to whether you can make a recycling claim. And if you do make a recycling claim, you will need to disclose that information, and not just in a teeny tiny disclaimer, but actually as part of the headline claim. So you might have to say can be recycled at most supermarkets or something like that. So I just want to talk a little bit about what we've learned from the enforcement so far, because obviously as of the beginning of this year, we saw the undertakings that the CMA required the fast fashion companies to enter into. And they made it clear that the CMA has very high expectations. It made it clear that they are expecting those companies, and I would suggest that we can all learn from this, to actually be monitoring all the claims that they're making, understanding where they're being made, training the staff to make sure that those claims are being made compliantly with the Green Claims Code. They're expecting spot checks on 5% of the claims. They're expecting you to have contracts in place with anyone who needs to provide you with sustainability information, requiring that information for there to be a system in place to actually collect it, review it, and keep it updated. And also that if you're making mission statements, they're expecting regular checks that you are keeping up to date with those KPIs. All of those require massive internal processes. So there's a lot of thinking that needs to be done about how to actually live that through different types of businesses, because of course those undertakings are designed for fast fashion, but the learnings apply pretty much to anyone who's making an environmental claim. There's also a point to be said that we continue to be in a high risk of enforcement situation. This has some implications if you are being investigated. The first is that so-called informal resolution with the ASA, where you agree to take down your claim and they stop the investigation, is rarely on the table because they are trying to make a point. They want rulings, they want decisions to move the agenda forward. So it's difficult to get informal resolution. But it also means because we're getting a lot of decisions coming through, our understanding of the law is moving very quickly. And it means that you need to stay on top of the latest decisions to understand what it means for your own claims. Finally, I just want to talk a little bit about the consequences of non-compliance, and it does depend which regulator you're in front of. As you saw from my slide at the beginning, a CMA investigation runs many months and sometimes years. It is an ongoing, very, very onerous process. It typically ends up in undertakings being given to make commitments which are somewhat voluntary in their nature, but there is that threat of criminal prosecution under CPUT hanging over you. An ASA investigation is typically shorter, although, you know, I've had ones, particularly in the greenwashing sphere, that they're running long at the moment. So normally you would do an ASA investigation in a couple of months. The environmental ones at the moment are, you know, longer than that, could be over a year, but they are shorter. They're a bit less onerous. And the main sanction is that embarrassing upheld ruling. Now, they can refer you for prosecution, either by trading standards or the CMA, but that's relatively rare. And then I just want to finally touch on the fact that as of April next year, the CMA is going to get additional powers in relation to consumer protection and advertising, which will apply to the law that underpins these greenwashing investigations. So there will be new sanctions on the table of civil fines up to 10% of global turnovers. And that applies in addition to everything I've just said. So nothing is falling away. This is not a replacement. This is new enforcement powers, and it means that they can fine without going to court, and they can also fine for breach of undertakings. And I'm going to hand over to you, Jude.
Thanks, Katrina.
Director's duties.
Thanks, Katrina. As Katrina said, I'm now going to spend the next couple of minutes looking at directors' duties, specifically in the context of greenwashing and ESG, before moving on to consider what your responsibilities are as in-house counsel. So, directors' duties, what are they? Where do they come from? Directors' duties are the legal obligations and responsibilities that directors owe to their company, and they are set out in various statutory and regulatory instruments, some examples of which can be seen on the screen, but there are many others, some of which Katrina has alluded to. The source and the scope of directors' duties will vary depending on factors such as the size of the company, the industry in which it operates, whether it's regulated, whether it's publicly listed, etc. And some of these instruments also include specific guidance on greenwashing risks, such as the FCA handbook, which includes reference to the FCA's anti-greenwashing rule. However, there is one set of directors' duties that's relevant across the board, irrespective of the size of the company or its sector, and that's the general directors' duties, which are set out in the Companies Act 2006. So these general duties are set out in sections 171 to 177 of the Companies Act, and they cover directors' duty to act within powers that are given to them to promote the success of the company, to exercise independent judgment, reasonable care and skill, avoid conflicts of interest, and declare benefits and interest in third-party transactions and arrangements. So far, pretty vanilla. Where it starts to get a little more interesting, particularly in the context of greenwashing and ESG, is when you begin to drill down into the detail of the requirements of the Section 172 duty to promote the success of the company. And you can see from the wording on this section on the screen, as greenwashing and ESG issues have started attracting more attention, and in some cases, director remuneration has also been linked to ESG matters, there's now greater pressure on directors to demonstrate that in discharging their duties, they have considered the long-term consequences of a decision, the interests of the company's employees, suppliers, customers, and others, as well as the impact of the company's operations on the community and the environment, and also the need to maintain a reputation of high standards of business conduct and fairness. People are often surprised when they read this, but this is not new wording. It has always been there. I think Section 172 has until now typically been interpreted narrowly, or the detail is overlooked by busy directors who are trying to get through a jam-packed agenda at a board meeting, or it could be that some directors have simply never read it, which is also possible. So what's the relevance? Well, we're starting to see directors' duties, and in particular Section 172 duties, being used as the basis for legal challenges about companies' ESG credentials and greenwashing claims. So 2 cases that I'd like to mention here that illustrate this are, firstly, a landmark case that was brought last year by Client Earth. That's a climate change shareholder activist group. They brought a claim against the board of directors of Shell plc. Client Earth sought to challenge and hold Shell's directors personally liable for failing to move away from fossil fuels fast enough. And they had already expressed concerns to the board about greenwashing, but they felt that those were not adequately addressed. Client Earth sought to rely on 2 of the statutory duties that we've just discussed, and that were owed by Shell's directors under the Companies Act. The first being Section 172, duty to promote the success of the company, and also Section 174, duty to exercise reasonable skill, care, and diligence. Ultimately, the UK High Court did dismiss this case, but and also Client Earth's subsequent application to appeal the decision was rejected. But I think the case has paved the way for future similar claims, and although it has been unsuccessful in the courts, from Client Earth's perspective, it has opened the gateway for future claims like this, and it has also been a success in terms of publicity. In another recent case, McGaughey and Anor versus University Superannuation Scheme and others, members of a pension scheme sought to bring a derivative claim against the directors of the university superannuation scheme. They alleged that the directors breached their duties, again, Section 172 duties, by failing to divest from fossil fuels, arguing that this was inconsistent with the scheme's stated commitment to addressing climate change. The High Court ultimately refused permission for the claim, concluding that the claimants didn't demonstrate that the scheme had suffered any immediate financial loss due to directors' actions. But again, whilst this case didn't succeed in the courts, it is another example that serves to pave the way for future legal challenges brought against companies based on directors' duties in light of any ESG or greenwashing failings. So where does this leave us? And what's in store? Well, scrutiny of ESG strategies and the extent to which directors are implementing them, as well as the accuracy of the communications that companies put out to the world, is, as you have seen and heard, very much on the rise. There's also an increasing amount of regulation in this space, for example, the ASA and CMA codes that Katrina discussed, but also there's been an influx of ESG reporting legislation in recent years, both in the EU and the UK. And with increased reporting obligations comes an increased risk of greenwashing. We're also seeing a broadening of the scope of directors' duties. For example, in a recent legal opinion commissioned by the Commonwealth Climate and Law Initiative and Pollination Law, it was held that directors should consider nature-related risks under their Section 172 duties, such as biodiversity loss and ecosystem degradation. So we're beginning to see a real move away from that very narrow interpretation of 172 and promoting the financial success of the company to the detriment of other stakeholders to a much more holistic stakeholder view of success. As discussed, regulatory scrutiny is also on the upward trend, and as a result of all of these aspects, we can be sure that there will be more litigation and shareholder activism to come, just as there was with the Client Earth case. So very much a topic that is not going away anytime soon. Turning now to consider your responsibilities as in-house counsel when it comes to greenwashing and ESG. Ultimately, you are a trusted advisor to the board. That means they will look to you for strategic guidance on ESG matters and emerging ESG trends and regulations. It is a very fast-paced area. There is a lot of information around. So facilitating the board's decision-making by presenting clear, concise, relevant information is a key responsibility. The board needs to also understand their duties and the implications of greenwashing and ESG issues on the company's operations and reputation, as well as the financial consequences of breaches, and you have a role to play in helping them understand that. In-house counsel are also responsible for raising the board's awareness of greenwashing and ESG risks and the associated legal frameworks. You're also going to want to provide training to board members on identifying and avoiding greenwashing, for example, in maybe annual financial or sustainability reports that they're signing off, and also the importance of transparency in ESG reporting and communications to stakeholders. Ensuring you understand the legal framework in this area is crucial, as with any area of law. Staying updated on relevant laws and regulation is key. Also, when it comes to governance, you will likely have a role to play in ensuring that there's a robust framework in place to support effective ESG management and mitigate greenwashing risks. This may involve taking a role in developing policies and procedures that integrate ESG considerations, ensuring accountability by defining roles and responsibilities for ESG oversight, facilitating stakeholder engagement, incorporate diverse perspectives into ESG strategies, and ensuring that your comms and marketing teams, if you have them, have the right support frameworks in place to help them mitigate greenwashing risk. Proactively considering, managing, and mitigating greenwashing and ESG risks is also likely to fall to you. And in-house counsel should consider conducting risk assessments to identify potential greenwashing and ESG risks, undertaking internal audits on environmental claims and third-party verifications, and ensuring as well that lessons are learned from any mistakes that might have been made in the past. I've included the SRA Code of Conduct for solicitors on this list because sometimes I think it's helpful to go back to basics and think about what our professional duties are as solicitors. And under the code, we have a duty of care to exercise reasonable care and skill, to warn, and a duty to uphold service and competence levels. So all of the responsibilities I've just described, they're not nice to have, they're really part and parcel of our professional duty to be competent. That being said, there is no need to be an absolute expert. Yes, you should know what areas you may be expected to advise on and do what you can to ensure you fulfill your professional duties in that regard, but also know when you or the board need to seek specialist advice, for example, from an ESG lawyer or a consultant. Ultimately, it's about putting your organisation in the best possible position to mitigate the risks of greenwashing and also compliance with wider ESG regulation, and just ensuring that it's on the front foot if there were ever to be any challenge. We always want these sessions to be practical, so we put together this checklist for you to use to take the temperature, so to speak, on how your organisation is managing greenwashing and ESG risks and help you identify gaps. In the interest of time, I'm not going to go through it, but we will be sharing the slides after this, so hopefully this is a useful takeaway tool for you to go and consider offline. Last but not least, some tips to help you stay ahead of the curve. So, horizon scanning. Stay informed about trends in greenwashing claims, enforcement actions, directors' duties, trends, and their implications for your organisation. We would suggest signing up, for example, to alerts from the ASA or the CMA. Those will help you keep track of recent enforcement decisions on greenwashing, subscribing to blogs such as Mills & Reeves ESG blog, industry publications, or engaging professional advisors to provide bespoke horizon scanning services. Documenting ESG risks. So documenting discussions and decisions at board level is a really helpful way to demonstrate, if you need to, that these are issues that are being given the necessary airtime and are being consistently monitored. We would also suggest that you ensure the risk register is regularly reviewed and updated to reflect ESG and greenwashing risks. Control over green claims. Ensure you know where claims are being made. This includes information in sustainability reports, website content, advertising, and marketing communications. We would suggest implementing a robust verification process for all environmental claims and ensuring that the relevant teams are aware of the risks associated with particularly high-risk claims like absolute environmental claims that Katrina talked about. If possible, have a centralised system for collating substantiation data and ensure it is using third-party audits when possible. Legal team preparedness. Assess the current capabilities of your legal team regarding ESG and greenwashing regulations and provide targeted training sessions to address any knowledge gaps. And you may want to consider engaging an ESG or greenwashing specialist to bolster your legal team's expertise. And finally, substance in ESG claims. ESG is a much broader topic than just environmental claims. While the environment is the current focus, attention will soon expand other aspects of ESG, and we should be ready for this and ensure you apply the same rigor to those areas and reports in those areas as you do with your environmental claims. I'm now going to hand back to Alison.
Thanks both very much. In terms of questions, we've got a few minutes, so I'll pick up those. The first one, Katrina, is for you. You mentioned the DMCC. What do the new powers given to the CMA, what do they now mean for the ongoing investigation into consumer goods and for future investigations?
It's a good question. So the CMA will, we think, in line with the government's announcement last week, acquire those powers from the 1st of April 2025. Now, the CMA has said publicly that it will be using those powers in relation to new investigations that start after it gets those powers. So certainly in relation to the third greenwashing investigation, which hasn't started yet, if that is announced after those powers come into effect, and I would suggest it might well be for this very reason, then those powers will be on the table for that investigation. I think it is. Well, the CMA has suggested that it won't be using those powers in relation to ongoing investigations. So insofar as we have an ongoing investigation at the moment into consumer goods, those powers probably won't be used because that's not really how this is supposed to work. Everyone's supposed to understand at the beginning of an investigation what powers are potentially on the table. So it shouldn't apply in that context.
And I think you've answered a follow-on question around, are investigations made public? So how are they made public and how is that communicated?
It's a good question. It depends actually on the regulator. So the ASA publishes all its decisions, not just on greenwashing, on a Wednesday morning. So this morning there was a bunch of rulings. Today we've had a couple about CBD. And some other topics. So it basically sends out, well, they appear on its website and you can sign up to get a newsletter on a Wednesday morning that'll drop into your inbox, and I read it every morning and see if there's anything interesting. Obviously here at Mills and Reeve, when there are interesting rulings, particularly in greenwashing, we tend to post something on our blog about what those rulings mean. So it might also be worth signing up to the ESG blog for that sort of analysis of key rulings. And you can sign up for the alerts on the ASA website. In terms of the CMA, they announce key stages in investigations. So they announce when investigations started. They'll usually announce when the first phase of a greenwashing investigation is usually looking at a whole market. And then they will zero in on certain players who they think there are particular issues with and investigate their specific practice. So it'll normally make a second announcement at that point. And there may be some other announcements going forward, but ultimately, if it ends up as we did with the fast fashion investigation, with the CMA entering into undertakings with various parties, then the undertakings are also made public. So you can sign up for alerts on CMA investigations, but it's not like the ASA. You won't get one once a week. You'll get one like maybe every 9 months or so. It's sort of quite sporadic, and it just depends on their own timings when they reach those key stages and they decide there's something to announce. So it's less regular because the investigations are much slower.
Right, thank you. And Jude, before we finish, this one is more for you. having touched on and emphasized the importance of these issues around ESG and greenwashing at board level, how do you bake that into board behavior? Do you have some advice around practical ways of building that into boards?
Yeah, good question, Alison. I think, training is obviously one fundamental aspect of it, and awareness raising. This is quite a specialist area and it's relatively new. So there's a lot of board directors out there who won't necessarily have a full grasp of the risks and the consequences of feelings in this area. I think from a practical perspective, ensuring that when they're making decisions, they are documenting the criteria in 172 that we talked about, that they have considered those aspects when they're making the decisions. If they're signing off for example, sustainability report, which most large companies are now publishing annually, then have they really rigorously interrogated the data? Are they confident that maybe their legal team has done that? And they need to be sure about those things before that goes external, because that's a key area for greenwashing risks. Ensuring risk registers are up to date and they're engaging with the business, setting a clear message and a clear vision and commitment that ESG aligns with the company's overall strategy, and it is not a marketing piece, and making it a standing item on the board agenda.
Brilliant. Thank you. Unfortunately, that's all we have time for, but I'd like to thank Jude and Katrina, obviously, for taking us through those key responsibilities, and thank you all very much for joining us today. As Jude mentioned earlier, the slides will be circulated along with a recording of the whole webinar. Please do leave your feedback at the end when you're prompted, and otherwise, we look forward to seeing you again next month. Thank you very much.